So I'm Mairead Painter, the State Long-Term Care Ombudsman in Connecticut, and we are joined today by Dan Beam, who is a manager on my team, many of you might know, and we're also incredibly thankful to have with us today Toby Edelman from the Center for Medicare Advocacy, and the expert, I would say, on a lot of these topics and who we often call for support in these areas. So Toby, thank you for being here with us today.
Thank you. I'm delighted to be with you. My favorite ombudsman, so it's great.
Oh, you're very sweet. We really wanted to reach out and talk to you because we're having more questions and concerns related to, one, admissions in skilled nursing facilities in general, as well as individuals' rights once they come off Medicare and what that looks like, the right to continue to stay in the facility, what they should expect, and when they can push back and say, no, this isn't what I want related to discharge, or when they should expect a bill. One of the things that we often hear is, oh, I'm in the short-term rehab. And so talking about the difference there, what that means, and the fact that most nursing homes, I think there's only very few in Connecticut that aren't certified to do both Medicare and Medicaid. And if they're certified to do so, that they should be keeping individuals. So just wanted to kick it off there with a little bit of an understanding of, when you're helping someone move into a nursing home. Why don't we start with the moving in? So when someone's moving into a nursing home, right, and they start to meet with the admissions director and they're asked to sign paperwork. Sometimes nursing homes are asking them to personally guarantee the payment for that friend, family member, loved one on admission. And we know that this is generally illegal under federal law, that specifically in the Nursing Home Reform Act, they're not allowed to do that, but we're seeing them do it in other ways. Can you talk about that a little bit?
Well, you're absolutely right that it is prohibited by the 1987 Nursing Home Reform Law to ask family members or even neighbors to sign an admission contract and obligate their own finances. They can only be asked to sign in a representative capacity. So if they have access to the resident's money, like power of attorney, they're responsible for using the resident's money to pay for care, but not their own money. And that's the federal law, and it's been the law since 1987, not new.
That's very helpful because you would think it was new with how often we hear this. And what do you think we should be watching for when people look at contracts? What are some things potentially in contracts that might come up that they should watch for or ask for more information on?
Well, if they should read the contract, and if possible, try to get it in advance, not just come in and how about just signing all these papers. That's really a problem because people don't read them, understandably so. I've done the same thing myself. When you're given a piece of paper and told to sign, you just sign. But really, people should try to get the contract in advance, and if possible, maybe even have an attorney look at it, make sure that it has the provisions that are legal under federal and state law. And if
Wonderful.
not, read it afterwards, and then go back and say to them, wait a minute, this is not appropriate. So we know that for having alternative disputes instead of going into court to require something else, there is a cooling off period in the law, and they can take that out of the contract later. They can come back under federal law. So that's, maybe we should say the same thing for other provisions that we think are illegal and overreaching on the facility's part. They might
Absolutely.
be they're putting in things now. They're saying, well, we don't have enough staff. So you need to know that there's not staff. And if you really want staff, you better hire your own staff. No, they're supposed to provide staff to you, and they shouldn't be asking families to pay for a nurse aide to stay with the relative. It's not right. They do.
Absolutely. We have heard that. That's another point I'd like to make clear, that if an individual is accepted into a nursing home, they're accepting them in their totality of their needs. They should be assessing for that. So they shouldn't never be coming back to a family and asking them to private pay for someone to sit one-on-one. If they've established that an individual needs support in a one-to-one way, or to facilitate the best quality of life for them and meet all of their individualized needs, then the nursing home would be obligated to provide the appropriate staff to meet those individualized needs.
They are not supposed to admit people whose needs they can't meet. They're supposed to make that decision. So if they admit somebody, they are saying we have the staff to provide care for you, and we should hold them to that.
Absolutely. And so when you're signing a admission agreement, we've also said if there's things you're not comfortable with, you can line them out and sign next to it, right? Strike it,
Sure.
sign that, nope, I don't agree to this. Just because they're putting it in front of you doesn't mean you have to sign for it. So understanding that I think is really important as well. Can a nursing home force you to pay if your family member, loved one, friend is there, and maybe due to something that they've done with their money, it's holding them up from being eligible for Medicaid, and there's a period of time where there's a gap? We see that happens, and we know that Medicaid will go back. They'll pay retro up to 3 months. So you have that 3-month buffer period to become eligible. But even outside of that, they shouldn't be charging other individuals outside of the person who is in the nursing home and their estate their own money.
That is true. There is no justification for having family members and neighbors sign and pay their own money. Not appropriate.
Yeah, and I think to touch on that, you mentioned like what are the things to look out for. I think when looking at a contract and you're helping an individual that you love or a loved one, sign in. If the individual does have cognitive limitations, they may ask a person to assist. And to Toby's point, the requirement that they assist in accessing the residents' funds. But be kind of leery about any time that they're defining what a responsible party is and defining a third party as a responsible party, because that's often ways that facilities try to subvert that federal regulation.
Yeah.
That they can't require third party guarantee is that they say, oh, you volunteered, you voluntarily did it. And I think that's very important for individuals to look at and consider when they're signing contracts on behalf of a loved one or a family friend, because that's how facilities try to catch you in that contract law.
Good point. Very good.
The other thing we're hearing related to Medicare, and I don't even know how much we've discussed this, Toby, is buildings asking the admissions or social workers to call residents or their responsible, I don't like word responsible party, the resident representative, and ask them to change to straight Medicare, telling them to be in the building, they have to switch over to straight Medicare versus a managed Medicare, because it's easier for the long-term care facility. And we've really stressed that there should be sort of a one-pager that talks about the pros and the cons of both, really encouraging people to call choices counselors to understand what that change would mean to them. People can only change the end of the month, right? The first of every month, it can flip to back and forth. But here in Connecticut, if you're a state employee or part of some teachers unions, you only have managed Medicare. You can't change. And so we really think it's inappropriate to be directing which type of Medicare someone has, that they should have the choice and be fully informed, and the nursing home should be working with them on that.
Absolutely. It's their choice, and it's more complicated than just saying, oh, switch back to traditional Medicare. As you say, a lot of people really don't have that option. I think there was a lawsuit, I'm trying to remember where it was, where a nursing home was prosecuted for flipping people from Medicare Advantage to traditional Medicare. And, they do it not for the residents' interest. They do it for their own interest, because traditional Medicare pays higher rates than managed care. And so they want the higher rates. And also, there isn't the prior authorization that Medicare Advantage plans have. Medicare Advantage plans will approve chunks of days, 3, 5 days, and then the facility has to come back and justify again to the managed care plan that the person still needs Medicare. Whereas traditional Medicare, the facility gets to do an analysis and say, well, we think you still qualify, we keep billing Medicare. It could be reversed by the Medicare contractors, but basically, if the facility documents why Medicare is appropriate for this person, Medicare will continue to pay. So it's in the facility's financial interest, although it's obviously helpful for residents too, not to have this second guessing all the time by the insurance company.
And
it is the resident's choice.
And just to make sure everybody has that information, I threw in the chat some links and the information to kind of contact your choices counselor here in Connecticut. They're Connecticut's counseling and eligibility screening program. They're free and they can kind of walk you through as a third party. Often this Medicare Advantage marketers will call and sell you their specific package. whether or not it may be in your best interest. And so the choices counselors can help you review your specific policy, your specific circumstances, and decide what might be the best one for you specifically.
Yes, and thank you for that, Dan. Dan is our links expert, so you will see lots of different links popping up in the chat today. Check them out. I think that it's great information for people to have, and it's really important to be fully informed in these areas. But Toby, I would love if you have a copy of that lawsuit related to
I'll
flipping
find
people.
it and send, yeah, I'll send it to
Okay.
you so you could link.
Great.
to
And
it.
we will post as much information as possible on our website as well, just so people have access to that information. Once you're admitted, you're talking about having that recertification and seeing that people, if they're on a managed Medicare, that's happening regularly. I know we've had a lot of calls about that. So for some individuals, it's kind of like harassment. They feel that, the managed Medicare is constantly cutting them off, and they're having to, as a resident or as a resident representative, constantly appeal that. And they're trying to get well, they have other things that they're focused on, and yet they're constantly having to appeal why they should continue to have covered days. And I know for us, we work really hard to connect them. One, get those appeals in, right? First, get the appeal in, get that done. It's KEPRO here. We make sure people do that, but then also contacting the Center for Medicare Advocacy. And we've had excellent support from them, from you all, on taking on those cases and supporting individuals in how to do those appeals, or sometimes, we hear about second levels of appeal, right? So if they get denied, people should even try a second level of appeal.
Yes, definitely keep appealing, because people have a better chance of winning, particularly if they get to the administrative law judge level. And there are very high percentages of people who win when they appeal, but most people don't. They're intimidated by the process, and they shouldn't be. And we're certainly here in our Connecticut office to help.
Yes, and that's wonderful. And I don't think people understand that they're supposed to receive the same level of care on managed Medicare and what's approved that they would on straight Medicare. There shouldn't be a difference in experience, although we often see that difference in experience and why they win so many of those appeals. So we really encourage everyone to appeal. If you have questions about appealing or concerns, you can reach out to us, but we really encourage people to reach out to the Center for Medicare Advocacy. We do want to know in our office that level of complaint, like how often it's happening, but CMA, Center for Medicare Advocacy, is the expert in that area. Moving on from that, once your Medicare days are ending and you receive appropriate notice that, let's say you are at the end of your Medicare covered days, we're hearing that for some individuals, when they come in short-term rehab, if they've now identified that they need long-term care, maybe they didn't recover the way that they had anticipated or at the rate they anticipated, and they're going to move on into long-term care and potentially even apply for Medicaid. What are their rights related to staying in that nursing home?
Before I turn to that, can I just say, when the nursing home says Medicare is not going to pay anymore, that's not a Medicare decision. That's a decision by the nursing home that it has made a determination that it believes, or it wants to believe, that Medicare won't pay anymore. But people have the right to have Medicare make that decision. And that's the first level of appeal, to try to retain Medicare coverage. And it sort of depends. It could be depending upon the reason they're giving you for saying Medicare won't pay. They might say, well, you've plateaued, not improving anymore. That is not a legitimate basis for Medicare coverage to end. There's a lawsuit that the Center for Medicare Advocacy did and settled more than 10 years ago called JIMMO, JIMMO, that says Medicare will pay, it will cover care in a nursing home, also home health and outpatient therapy, if the person needs professional nursing services or professional rehabilitation services to maintain function or to prevent or slow decline or deterioration. So even if people aren't getting better, but they need these services to stay where they are, maybe slow down the decline from a chronic illness, they're entitled to Medicare coverage. So now the question is, what happens?
Well, I want to ask you
Medicare...
something on that
Okay,
now.
all
How
right.
come? So why don't nursing homes use that more often? We've heard of JIMMO. We push people to use JIMMO. Why wouldn't the nursing home continue along that path, because we really think that maintaining someone's maximum abilities, right, keeping them from seeing any decline. When you don't use it, you lose it. The more you sit, the more you
Right.
don't engage. Why wouldn't a nursing home continue to bill under Medicare in that way versus taking them off?
Well, they should, and they do love it. The nursing home industry was very supportive of that litigation and wrote declarations for us because they see that Medicare is the highest payer. So they want that, but they're worried about being reversed by Medicare contractors saying you shouldn't have provided those services. That doesn't happen as much, but they're afraid of it. They're worried about that. But it
Okay.
is definitely the resident's right to have Medicare decide if coverage is available. And for that, people really need the support of a physician, if at all possible, to say why the person needs the therapy services or the 24 or the registered nurse coverage. Not just because I'm the doctor and I order it, but specifically, what does the person need and why? What is this necessary for? So sometimes they will say it's necessary so that the person can be able to transfer, like from the bed to the wheelchair, from the wheelchair to the toilet, so that the person can go back home to assisted living. Assisted living is going to want that. They need to get there. And so they need those services, the therapy services, to regain those skills. That's an important part.
Got it. Thank you. So let's say they've done that. They're at the
Okay.
point where now they're at a level of what's considered custodial care. So custodial care is, the definition means that they're providing you with support related to your activities of daily living, but there isn't a skilled hands-on care necessary in order for you to maintain at that level and be supported. So once someone's there and they receive notice, let's say it's appropriate notice regarding the ending of Medicare, what should somebody expect then?
Well, they should still be getting the services that are in the care plan, whatever they need. So if therapy is necessary 3 days a week, they should still be getting it under Medicaid. That's one thing. But one thing to know is that when somebody is applying for Medicaid, they've been on Medicare, never been on Medicaid before in their lives. As you said, Connecticut will pay retroactively up to 3 months. So people have the right to stay in the facility while they're waiting for the determination about whether they're going to be covered by Medicaid. And the regulations from the federal regulations from 2016 say specifically that that is not a non-payment situation. If the person has completed the paperwork, is waiting for a Medicaid decision, that is not non-payment, which is one of the few permissible reasons for discharge from the facility. So they can't do that. So people should know that if they're applying, they have the right to stay.
Right, because they're in a pending status, right?
They're
So
in a
once they're in a
pending
pending
status.
status, they should not be discharging them. And then even after that, they need to be 15 days fully in the rears before they can, with no payment, before they can issue them notice.
Well, that's a
One of
whole
the,
separate law. That's
Yep.
the nursing home reform law. There are two things. One set of laws concerns whether Medicare will pay for the stay. But if Medicare decides it's not appropriate anymore, person only needs therapy 2 days a week, doesn't need skilled care the other 5 days a week, so it's not a Medicare Part A covered stay. Nevertheless, the facility can't be stopping the services for the person. They got to provide them whatever the person needs.
Okay. And then one of the things that we've heard more recently is I was admitted to the short-term rehab part of the building, and they've told me they don't have a long-term bed available in the other part of the building, so I need to go somewhere else now that I'm applying for Medicaid.
Well, Medicare does not certify specific beds. All the beds in the facility are available for Medicare, whether the person needs those services to improve or to maintain function. It doesn't matter. There isn't a short-term rehab. Medicare does not recognize that in certifying beds. All the beds are certified, and as you said, for Medicaid, same thing. They're all certified. So all the beds should be available for everybody, wherever they are, whatever they need.
We agree with that. And so when we're hearing that, what we've expressed to people is the facility, because that would be discrimination. If you're discriminating against someone because you want to be able to bring someone in under short-term rehab versus someone who's applying for Medicaid and needs a long-term stay, that they should be waiting, right, for the bed availability in the building. Here in Connecticut, they do allow them to have short-term sections, but just because you're off short-term rehab does not mean that there is a legal reason for them to be able to discharge you or ask you to leave. And actually, they're required, if they're suggesting that you leave, and it's not your idea, you didn't wake up and go, I'm going to leave today, put a discharge plan in place, I would like to go, that they should be sending us, they're required to give you notice of involuntary transfer or discharge. And so that if they're asking you to go to another facility that accepts Medicaid or has a long-term bed, that would be an involuntary transfer. And if they're saying that they're going to transfer you home or discharge you to home, and you don't think you're ready, it would be an involuntary discharge. And so those notices are supposed to come to our office through a portal on the same day when they're going to the resident and the resident representative. And so often we will get a call and then we look in our portal and come to find out we do not have a notice on that person. So we'll call the building and say, you've not issued notice. And so if you don't issue notice, you can't work towards discharge with that individual. And it actually keeps them from having their appeal right, because if we receive the notice,
Right.
a regional ombudsman would reach out to them and ask if they wanted support related to that notice. And if they wanted our office or the regional ombudsman to help them understand their rights around that. So if you're being told that you need to discharge from a nursing home after short-term rehab, please give our office a call, at least find out what your rights are, call the Center for Medicare Advocacy to really understand your appeal rights or your ability to be able to stay in that facility and move over to another section of the building or have another bed when it's available. They can transfer individuals, again, from a private room to a semi-private room if they are on Medicaid. If they transfer over to Medicaid and they don't want to pay a private pay rate for the private room, they do have the ability to transfer you to one of the rooms in the other area that's long-term and usually semi-private. But again, if you have any questions or concerns, that's where we would really encourage you to reach out and get some support around those rights.
Yeah, and
Well,
I think
the whole thing, I'm sorry, go ahead, Dan.
no, I was thinking, Toby, as well, just as something to touch on is, even if you have to be transferred to another section of the building where you had maybe previously a private room, but now are a semi-private room, and moving into a Medicaid, semi-private room, facilities have the federal obligation, state and federal obligation to provide consistent and quality care, no matter what portion of the building you're in. And the same policies must be enacted, and for one side, that's another. And so if there's ever concerns that maybe you do have a transfer from one room to another and you feel that the service or care is not adequate or is not the same as it was in another section of the building, that's another example of when you could reach out to our office for some support regarding that, because facilities have the federal and state obligation to provide consistent and quality care, no matter what payment you have or what
Exactly.
section of the building you're in. So just wanted to remind that.
Exactly. That's what the federal regulations talk about, equal access to quality care. It should not be based on source of payment. Everybody should get the same care. Whatever they need, whatever is in their care plan, that's what they should be getting. But I think it's important, Mairead, about discharge from the facility. This is a whole separate set of regulations from the 1987 Nursing Home Reform Law, which Connecticut has also expanded upon. Facilities can't make you leave the facility. Once you're there, this is where you live, except for certain specified reasons. You need more care than they can provide, or you don't need the care they provide, or you're a danger to yourself or others, or the facility is closing, or non-payment. And as I said, applying for Medicaid is not having that application in process is not a basis. That is not non-payment. It's very explicit in the regulations that were put out in 2016. So that's important. People have a right to stay in their home. They have to give you advance notice. They have to tell everything you just said about the notice going to the ombudsman as well. So it's a written notice. You have a right to a hearing, and the burden is on the facility to show that one of the permissible reasons has been met. They can't just, it's not on the resident to show I need it. It's on the facility to show that the resident has to move.
And that you're a resident there, no matter how you got there, right? Whether it was short-term rehab, whether you were admitted for long-term. Once you are a resident in that building, you are a resident in that building, and you're protected by these laws. And so I think what we're hearing is, oh, we don't provide that level of care in these beds. Yes, they absolutely need to provide that level of care in any beds if they're duly certified. If it's a building that has Medicare and Medicaid anywhere in the building, they're duly certified. If you have a question related to that, because again, we have some very few buildings here in Connecticut, less than a handful, that are, I believe, that are just Medicare. And so after your Medicare days, but they should be telling you that before you're admitted. You should have full knowledge of that so that you're making that decision when you're accepting the bed there. I think that's really important to know. They are required to tell you what they're able to provide or not able to provide prior to admission.
Absolutely.
So that's a portion. When you're in the hospital, you should know those things. And then when I think something else you said was really important, Toby, around care planning, you should receive a care plan as soon as you're in the building. They should be assessing you for your plan of care. And that is not something that the building just writes, right? That's not something the nursing home comes up with. That is something that they should be meeting with you and your identified support system. So family, friends, anyone important in your life, they should be inviting you and those individuals to meet and to discuss what your personal goals are, your preferences, your priorities, and how you receive or reach those goals, receive those services or reach those goals should be discussed with you. They should be helping you meet those individualized goals and working with anyone who you identify as important. And those meetings, we often hear that, oh, you're only going to have 15 minutes. That's not okay. You have as many minutes as you need. And if you want the support of a regional ombudsman at one of those meetings, either virtually or in person, we can do so. We can talk to them about that, but they should be offering them to you in a comfortable area, your room, a private space, wherever meets your individualized needs, and providing them at a time when your necessary support to the people you identify that you want there are able to attend. And you should have as much time as you need in order to talk about anything, your care, your services, your goals, and how those are going to be met.
You know, it's also your home. And one of the unique changes of the 1987 nursing home reform law, first health law that ever talked about this, is quality of life. You're not only there to receive health care, and you are not expected to decline, you're expected to maintain your level of functioning unless something medically happens to you, but also you're entitled to a decent quality of life, have meaningful activities, be able to interact with people you like inside and outside the facility. So, you know, this is your home. People have a right to vote. They retain their rights as citizens. You're not a prisoner in the facility. You have a right to live your life as fully as possible. And it should be encouraged and supported.
That's an excellent point. One, everyone has the right to vote. Anyone can vote. Unless you lose your right to vote for some reason, you have the right to vote. And people in the facility should not be deciding that for you. If someone wants to vote and needs assistance with voting, that's something we are also very focused on. And the ability to have a good quality of life. For some people, that means going out for religious participation. If you're on Medicare, you can leave the building. We sometimes hear that. If I'm on Medicare, they said I can't leave for any reason. That's not true. You can leave. They ask that you provide notice, you get the support that you need, especially if there's physical support that you need, either transferring in and out of a car, those types of things. But if you have questions related to having the ability to have a full quality of life and maybe going out for a ride, we had someone that wanted to go out for a ride and get an ice cream. They transfer it to the car, they take a ride out on a beautiful day with a support person, maybe get an ice cream and come back. That's something they're able to do, even if they're on Medicare. So sometimes we hear that, and I want to make sure that that's clear.
Mairead, I just want to say something about that. We've written about it a lot of times in our office called Home for the Holidays, because what Medicare says is if somebody comes back by midnight, you know, Medicare always counts midnights, not days. If somebody goes out in the afternoon, comes back by midnight, even if the person's been gone 5-6 hours, the facility can bill Medicare for that day. The question comes up if somebody stays out over midnight. Sometimes people will go home for a holiday meal and stay overnight with the family for Thanksgiving, for Christmas, whatever, graduation, weddings, all kinds of family events that people want to be somewhere. Medicare says facilities shouldn't take such a strict view that if you're out overnight, you can't come back or Medicare won't pay. Now, the rules have been changed and they're allowed to bill the resident if the person is out overnight, as long as they've told them in advance and the person agreed to it. But you're not, again, you're not a prisoner. You can leave and come back and resume your Medicare stay. It's very important.
That is, and we often hear that, head in the bed at midnight. Where was the person's head at midnight?
Right.
But you also brought up discharge planning, and I think it's really important for people to know that discharge planning should begin the minute you step foot into the nursing home or before. They should be talking to you about what your discharge plan is. And even after someone has decided that they are going to stay or need more support related to long-term, right? So if they feel like they need long-term services and supports in order to stabilize, in order to have their individual care needs met, the skilled nursing facility is still required to ask the resident, not the family member, not the resident representative, but to ask the resident, even if they're conserved, to ask the resident if they would like to be assessed on a quarterly basis for a living situation that might be less restrictive. So part of the Olmstead Act says that individuals must be asked if they want to be assessed, because I've worked in this field for years and I don't always know all of the resources and supports that the state has once someone is on long-term services and supports and covered, especially by Medicaid. Here in Connecticut, we have something called adult family living, where someone can receive supports. We have residential care homes, which are less restrictive. Individuals can apply to receive rental assistance to go to an apartment. We want to ensure that people's homes are maintained, right? You can defer income for the first 6 months in order to help support and maintain your primary residence. So those are things people don't always know and aren't always informed of by the nursing home. So if you have questions related to that, you're welcome to reach out to us. But that discharge planning should start right on your first day. And so sometimes we hear, well, I said I was going to stay long-term. Why are they still asking at the care plan meeting what my discharge plan is, or if I would like to be assessed? And that's because they're required by law. Section Q of something called the MDS, which they do every time you're having a care plan meeting, the minimum data set assesses how you're doing, what your needs are, how much assistance you need. And it's done by section. And section Q of that really pertains to the individual and what they want. So if someone's conserved and their conservator says they don't think that they should return to a less restrictive setting, that individual actually has rights to ask for their other attorney, the one who represents their desires, to take that back to probate court and have an actual finding by the probate court judge as to whether or not the person can proceed with the assessment. Just because someone's assessed doesn't mean that there's going to be able to be a plan or what those services might be or what that would look like. And so we really encourage everyone to be assessed. And so I would never make a decision. I don't know about you two, Dan or Toby. I would never make a decision related to my health, where I was going to live, what I was going to do, unless I had all the facts. You can't have all the facts unless you're assessed and you're being given the information.
Absolutely. And I'll just note, as you guys have been talking and we've kind of dovetailed into several different resident rights over the course of this conversation, I've been trying my very best to include links to all the various rights that we're talking about in real time. And Toby, I was even able to get your rights regarding Medicare Home for the Holidays up. And to expound on that topic, under the Medicaid rate reimbursement, individuals are permitted up to 21 days of absences to go home throughout a calendar year from a facility. So it's not just exclusive for individuals under the Medicare benefit. Even individuals on Medicaid have the right to have the facility reimbursed for up to 21 calendar days per year and still go home, visit with family, and be able to return to the facility as desired.
And so, Dan, I just want to, because sometimes we hear that 21 days and that's 21 overnights. You can go in and out of the facility as often as you would like, as many days as you would like. But it's 21 times your head isn't in the bed at midnight, is how we would measure that. And so understanding that too, right? And knowing that, well, I'm really going to want to go spend time with people around the holidays. If I go away for a few days during the summer with someone, and then I know I'm going to want to go out again around and be out of the building around Thanksgiving, Christmas, Hanukkah, any holiday, that you plan for that, right? We want people to be planning. It's also something really communicate with. We have some nursing homes that are really great at care planning, right? And discharge planning. We have buildings that do a great job at this. The ones that really care plan well are the ones that talk to individuals about what are your goals? What do you see as your goal today? What is your goal in 3 months, 6 months, a year? And working with the individual on meeting those goals, because then it won't be a surprise to the building either, and they will be able to appropriately plan with that individual and their support system on how to reach those goals. Let's see, I'm trying to see what else we have here. Reporting violations. We also want to encourage people to understand that if anything happens at a nursing home, we're going to be doing other series on this, but what are the obligations regarding reporting? You might see in your nursing home some pamphlets coming from us or some information. There'll also be information on our site. We're going to do a pamphlet related to this and ensure that it's accessible in all of the nursing homes related to short-term care, long-term care, admission and discharges. And then one of the next series we'll probably talk about is abuse, neglect, and exploitation. And when those types of concerns in a long-term care facility need to be reported and who they have to be reported to. Here in Connecticut, if you have an allegation of abuse or neglect, the nursing home should be reporting that to the Department of Public Health, as well as the Department of Social Services. And they should be asking you if you want our office involved. So if they don't ask you if you want our office involved, you should be encouraging them to make sure that they do that and that they fill out the appropriate forms, W-410, and to get that sent in to us so that it'll alert us that there's a concern and that we can make sure that you have the appropriate supports around that. I think that's all I have for today. Toby, is there anything else
I had one thing. No, there's one other thing I wanted to bring up related to discharge, and that's what happens when someone goes to the hospital.
Oh, yes.
You know, the federal, sometimes it's obviously person really needs to go to the hospital, but we have heard of situations where facilities use it as a pretext, send someone to the hospital and say, okay, now you're in the hospital. Okay, you're gone. That is not permitted. The regulations, the federal regulations say if someone goes to the hospital or leaves on therapeutic leave, the 21 days that Connecticut will pay for, goes home for the holidays, wedding, the facility has to give the resident a written notice explaining bed hold policies. So they have to know Connecticut's bed hold policies, what's going on with Medicare, and then they have to say what their own policies are, which need to be consistent with the state law and with federal law. And then the resident has to be allowed to return to the facility, to the previous room, or if it's available, or to the next semi-private room if the person is eligible for Medicare or Medicaid. Now, if the facility says you really can't come back, we can't provide the services to you anymore, then they have to go through the formal discharge of giving the notice and allowing the person to have a hearing and to contest the discharge. So the condition of the person, when it says we can't meet your needs now, is the condition when the person is ready to come back, not when the person was sent to the hospital. So they would have to prove this again, but this is something new from the 2016 regulations, I believe, that the facility would have to consider this a discharge. If they want to have a discharge, they've got to go through all the discharge requirements. And giving people the notice, then you have to be informed, Mairead, that we have this person in the hospital, can't come back. So that's important because there have been situations where people are sent to the hospital and not allowed back, and they need to be able to go home.
And that's a great point. Thank you for bringing that up, Toby, because there's two things we hear. One is, well, we're not discharging them. We're just telling them that we can't take care of them. They should go to this other facility now, our sister facility, somewhere with a behavioral unit, and that's not acceptable either. Once you are a resident in the facility, you are their resident and they need to meet your needs in totality. If they can't and they send you to the hospital, they say, whatever reason they can't, one, that's an involuntary transfer, and those still must come to our office and you must receive notice. So it's transfer or discharge, and you have appeal rights. And during an appeal, the resident has the right to return to the nursing home pending appeal.
Yes.
Many times we'll hear they're a danger to self or others. And again, as Toby commented, it is not about when they left the facility, it's after they receive the support that they need. If they've had their needs met and it's a different situation at the hospital, they then have the right to return. Here in Connecticut, we have something called a consultative process. If the nursing home still says they're not taking the person back, they must, within 24 hours of the hospital saying you're ready. So the hospital says, you're ready to leave, and the nursing home says no. The nursing home has 24 hours to say we're not accepting that person back or to ask for a consultative process. So they must either issue you notice or ask for a consultative process, which is physician to physician, hospital to nursing home. And so maybe something happened at the hospital, right? Maybe they put you on a type of medication or a treatment. If someone needs ventilation, they need a ventilator support. Not all nursing homes have the ability to take someone that needs a ventilator. So that, but they would still need to give them an involuntary discharge explaining that. And it's really important that the physician speak to physician to see if there's anything that can be changed or anything appropriate, medically appropriate, that they're asking for, to say, if this changed, then we would be able to take the person back. Otherwise, the person should return to the nursing home pending appeal and have the supports that they need. If that doesn't happen, again, that should be when we're receiving notice at our office. You have the right to call us. We will intervene. Department of Public Health will intervene, because nursing homes should be accepting people back to their homes. Once you're there, it is your home. And if they've accepted you, we hear this now in a way that we didn't before, especially with individuals who have a diagnosis of cognitive changes. And they'll say, well, the person progressed and we're not able to support them, or they've started wandering. They need a locked unit. A locked unit isn't a requirement. That's if they're doing it for the needs or to support the staff in the nursing home, that's not okay. They should be able to meet your individualized needs. They should have the staff to appropriately meet your needs, not using a lock on a door for that. And to sign someone into a locked unit, just so you know, on admission or for continued care, you need to be the person in agreement or have the legal authority. So a conservator can't just sign for someone to be on a locked unit. That is a higher level of care, and they would need to bring that back to probate court and have the permission of probate court in order to sign someone into that unit. If there's someone on a locked unit that is asking to be off the locked unit, the nursing home is required by law to assess you and to provide you with the least restrictive environment, again, off a locked unit, or have someone that has the permission to sign on your behalf to be on that unit. And so we see that as a big concern here. We have a lot of individuals who are placed on locked units for the convenience of staff. They say it's for the person's well-being, for wandering, but they should be able to support them, have the whole building wander guarded, right? Supply a way for the person to have freedom of movement, attend programming, be throughout the building, support them if they're needing to move about and need some guidance around that. They should be doing that versus having them on a locked unit.
I think one thing that you're touching on, and I think just to kind of bring it home and remind individuals of it, is really their right to be informed in writing. Often individuals are told things ad hoc by the facility, and they take the word as gospel. And I think in reality, what people forget is that they have the right to get that information in writing. And this goes all the way through all the topics we're talking about. If we're talking about your admission contract, it's in the contract. You have the right to have it in the contract or discuss it from the contract. If we're talking about a Medicare denial, you have the right to receive that formal Medicare denial in writing. If we're talking about changing your room, you have the right to be notified in advance of any potential room change or roommate change. Depending on the timing, that could be 15, that could be 30 days in advance, or at the time of, if an emergency. If we're talking about an involuntary discharge, you have the right to be informed in writing of this. And I think that's so key, because individuals might take what a facility is saying, might misunderstand or misconstrue what they're saying, and act in a way that they don't necessarily have to, because their rights are saying you have the right to get this information in writing. And often, just by saying no or by appealing any particular denial, you can uphold your rights in a stronger way. And so just reminding individuals that any issue or concern, you often have the right to request that in writing.
Absolutely. And you touched on two things there, Dan. One, everything we're talking about really goes back to residents' rights. So if it's in the resident right and they're asking you to do something in a different way, you should be receiving that in writing. Residents always have the right to be restraint free, whether that be a physical restraint, like a door locking or a belt on your wheelchair, side rails, anything like that. Residents have the right to be restraint-free physically also, but with medication. If you're receiving a medication that you're not comfortable with, having the ability to talk to your physician about it. As we were talking, I'm like, we could go down 8 rabbit holes here. But the other thing we've heard on admission, just so you know, Toby, this is coming up, and we've talked to the hospitals now about it and the nursing homes, they cannot make a condition of agreement related to your admission. So for some hospitals, we've heard that when they have an individual that it's a challenge to find a nursing home to take, or there's a, for some reason they're not finding an accessible bed, they make an agreement where if it doesn't go well in the first few weeks, you can just send them back to us and we'll find somewhere else for them to go. We have made it very clear, you cannot have a
Wow.
condition of agreement. Once someone is your resident, they are your resident, and you live there. And so if they're telling you, oh, well, we said we would try this out, there's no trying out. Once you're accepted as a resident, you're a resident. And so if you're hearing that, if you're experiencing that, please let us know. We have let the hospitals know that they cannot do that, and that the nursing home should know that they're not able to take people on agreement. So again, if someone's telling you that, please let us know. But maybe we should do these even quarterly, because I feel like there's so many topics out there that we hear from people, and information that individuals need. And the more that we arm people with information, the better their quality of life and their stay is. And that goes for the individuals working in nursing homes too, because I think for a period of time, we haven't had the level of education and outreach. When I was a social worker in a nursing home, we had a lot of shepherding. So for a number of years, I had people who taught me, right? And who taught me these regulations and what was required. And now we see a lot of change. We see people who are newer, who don't have the benefit of that kind of shepherding that I had, or that other people have had the access to. And I think that's a real gap right now.
You know, I
Dan,
think we've been talking about how important the care planning meeting is, and I was reminded of conversation with a previous state ombudsman in Connecticut, Barbara Frank, who was talking about one of their clients who was in 4-point restraints. And it was horrible. It was really horrible. This was when restraints were used more, obviously. We know better now. But they had a care plan meeting, and the facility asked the daughter, what does your mother like? What did your mother like? How did she like to live her life? And she said, well, she liked to sit in a chair with a blanket and a glass of warm milk and read a book. And so they said, okay, let's try that. And they did. They took her out of her restraints. She sat in a chair with a blanket, warm glass of warm milk, and a book. Now, whether she understood what was in the book or not, she was very comfortable. It was familiar and happy, and she felt better, and they got rid of the restraints. I mean, the idea of it, talk to the families. I mean, for the residents who are able to say what they need, what they want, the facility should be listening to the residents, obviously. But if the resident can't verbalize what is necessary to give a meaningful life, they should be talking to the family, to the representatives, and finding out. And if that's what the person needs is a book and a chair and some milk, then let's do that and make life as good as possible for the people who are living in the facilities. So
And the
hold on
education
there.
around that, to that point, the education around that, because we hear from facilities sometimes, the nursing home will call and say, the family really wants the person restrained because they don't want them to fall again. And so I want to make it really clear, people don't stop falling because they're admitted to a nursing home. Once an individual experiences a fall, the likelihood of them falling again increases every time. And so moving someone into a nursing home will not decrease their risk for falls. Now they can put interventions in place. They try to support the individuals. There's people around to help, offer them suggestions, maybe sit down and take a rest. It's maybe there to help grab them if they start to fall, but it's not foolproof. And putting restraints, there's a lot of information out there. We can provide people with information about what happens when you put a restraint in place and the person doesn't understand the restraint or doesn't want the restraint, that sometimes the injuries that are impacted on the individual are greater than if they fell and didn't have the restraint. Yeah. And you can't sign away a right. So people have rights. You can't, be asked to sign away a right. And if you make a decision about something and you agree to something in a nursing home, you always have the right to change your mind, even if they asked you to sign for it or you signed it on a care plan initially. All right. I know this. I love talking with you, Toby, and that's why we've decided to record some of these kind of conversations with people like you around the country, because I think we have these conversations all the time with peers.
Yeah.
And it's so important.
We know that facilities can provide good care to people. And we usually get complaints, right? People don't call and say things are great. But I had a call from somebody about her mother in Massachusetts, and she said her mother really loved the facility. I said, well, tell me about it. She said, well, before her mother went into the facility, her diabetes was completely out of control. But when she was there, medically, she was doing better. It was under control. So she felt better physically. They had a beauty shop that she could get her hair done every week, which was very important to her. And the third thing is that she spoke Portuguese. There was a resident in the facility who only spoke Portuguese. And so this woman's mother was her translator, and she felt she had a purpose. So she felt better physically. She felt she looked good because she could get her hair done, and she had a real purpose. I said, that's what we want as many residents as possible to have as good a life as possible, even with limitations. And I remember saying this to some of the nursing home people, and they're like, oh, okay, that's what you think it should be. I said, yes, that's what I think it should be.
Quality of life, right? That equals quality of life. And we see, that's what I love the smaller nursing homes that are scattered throughout the state, because what I see when I go there, we are very fortunate. We have a lot of fantastic nursing homes, and we want to ensure that whenever someone goes to a nursing home, no matter where it is, you don't have to be lucky enough to get into one of the good homes, that they should all be good homes providing high quality care where people have a high quality of life. And so we are fortunate to have a lot of those here in Connecticut. And my team does quarterly visits. And so they identify if there's changes, they identify if there's concerns. And most of the times things are going, very well. But we want to ensure that people have those choices and that ability to live well, and they're choosing to be there. And sometimes when they're smaller in community, they see people they haven't seen in years, right? So if they've been home and maybe not as active or able to do as much as they historically had done, I love when you go to a nursing home and you see people who come in for short-term rehab or reconnect in a way after not seeing each other for years, or maybe they grew up together or they knew each other for the community and lost touch because of some of those barriers. And then having that ability to be a community, to go to resident council, to support each other, revitalizes them. And you hear that from families. All of a sudden, someone will blossom when they're at the nursing home. And so they decide to stay. They want to stay long-term because it really has offered them that sense of community again. And in that way, I think it's a beautiful thing. And we've seen a lot of success stories. But any last comments or closing comments, Toby?
No, that's all. Thanks so much. Thanks for the chance to be with you today, and Dan, really appreciate it.
Couldn't be happier that you were here with us today and offered your time. Thank you so much. And Dan, thank you for always, well, one, for your comments and great input, and for always having all the links and connecting people to that direct information. So greatly appreciated. Thank you all so much. And hopefully, if you have ideas of topics that you'd like us to discuss or you want more information about, please either email us, put it on our Facebook page. Let's see, we have our website, our Facebook page, email. We have lots of ways you can contact us. We're also using QR codes. So you'll see on our posters, there's QR codes now. If you just scan them, it'll link you directly on how to contact our office. So thank you. And thank you again, Toby and Dan. And we will talk to you all soon.
Thank you.
All right. Bye-bye.